Welcome to course Company Law and Secretarial Practice. Myself, Sridevi, Senior Grade Lecturer, Government Polytechnic, Bidar. Today's session is Unit 2, Company Formation, Session 16. Table of Content. Meaning of Articles of Association, Contents of Articles of Association, Memorandum of Association versus Articles of Association. Learning objectives to analyze the legal provisions in the formation of the company, to acquire the knowledge and understand the secondary document of the company, that is articles of association, its contents and the difference between memorandum and articles of association. So let us know the meaning of articles of association. Articles of association is the secondary document for the formation of the company. So articles of association is an important document which contains the rules and regulations for the internal management of the company. They lay down the powers, rights of directors, shareholders and company officers. For the internal management of the company, some of the laws, that is the rules and regulations, are to be framed by the company. The bylaws for the internal management of the day-to-day affairs of the company are to be specified in the articles of association. According to Supreme Court of India, the articles regulate the internal management of the company. They define the powers of its officers. Contents of articles of association. What contains in the articles? So that means they contain share capital and its division into different clauses. The share capital and different division of shares, so that have been are intended to issued by the company. So their rules, regulations, the provisions relating to that are to be framed in the articles of association. Rights of different types of shareholders. If the company is issuing more than one type of the shares, in that case, each type of the shareholders' rights are to be specified. In that case, the provisions and procedures relating to the rights of different types of the shareholders are to be contained in the articles of association. The provisions and procedures relating to the allotment of shares, that contains in the articles of association of the company according to the Companies Act of 1956. Calls on shares. So the provisions and the procedure relating to the calls on shares are to be contained in the articles of association. Transfer and transmission of shares. The provisions and procedures relating to the transfer and transmission of shares according to the Companies Act, that has to be contained in the articles of association. Surrender and forfeiture of shares. See, if the company intend to surrender or forfeit any of the shares of the shareholders, in that case, the provisions and the procedure relating to that are to be contained in the articles of association according to the Companies Act of 1956. Conversion of shares into stocks. If the company intend to convert the shares into stocks, the provisions and the procedures relating to the conversion of shares into stocks according to the Companies Act, that is to be contained in the articles of association. Issue of share certificate. After completion of the allotment of shares, the company has to issue the share certificate to the concerned shareholders. In that case, the provisions and the procedure relating to the issue of share certificate, that has to be contained in the articles of association. Alteration of share capital. Alteration of share capital. If the company intend to alter the share capital in any stage of the company, in the lifetime of the company, in that case, the procedure, provisions relating to the alteration of the share capital should be specified in the articles of association. The powers, duties, qualifications, remuneration etc. of directors, managers, and any other higher rank officers. So their powers, duties, qualifications, and remuneration to be contained are the provisions relating to that to be specified in the articles of association. Shareholders and directors meeting. In the company, oftenly they may be convened the shareholders and directors meeting. So in that case, the provisions and the procedures relating to that meeting that to be contained in the articles of association according to the company's act. The quorum of the meeting, voting system of the meeting. So that to be specified in the articles of association. The method of bookkeeping and accounting. The company, whatever the company is following the method for the bookkeeping and accounting, their procedure and the provisions on to the company's act that to be contained in the articles of association. And there comes the winding up of the company. In any case, the company intend to or wishes to wind up the company. In that case, so whatever the provisions and procedures are related to the winding up of the company, that has to be contained in the articles of association according to the Companies Act of 1956. Coming to the memorandum versus articles. In the previous sessions, you may be known about the Memorandum of Association. Memorandum of Association is an important document for the formation of the company. So in the same case, Articles of Association is a second important document for the formation of the company. So let us know the difference between or the differences between the articles and that of the memorandum. So in one side we take the memorandum of association and the other side articles of association. So memorandum of association containing the fundamental conditions. So memorandum of association, it contains the fundamental conditions upon which the company is to be formed. Whereas articles of association, it containing the bylaws or the rules and regulations of the company. Whereas articles memorandum of association, it controls the external operation of the company. Here the external operation means the relationship between the company and that of the outsiders. So it relation between the company and the outsider. That means the memorandum of association controls the external operation of the company. Whereas articles, it controls the internal operation of the company. So the relationship between the company and the members intersect. The members intersect within the organization, within the company. So the relationship between the company and its members and intersect. So that relationship in order to control or in order to manage the internal affairs of the company, they control the internal operation of the company. So memorandum is a primary document. Memorandum is a primary document for the formation of the company. Whereas articles, it is a secondary document for the formation of the company. Memorandum is subordinate to Companies Act. Memorandum is subordinate to Companies Act, whereas articles is subordinate to Companies Act and also Memorandum of Association. Memorandum cannot be altered easily. So for the alteration, the contents of the memorandum are not altered easily. So in that case, the procedure for the alteration of the contents of the memorandum is very complicated one. So the procedure to be followed for the alteration of the contents of the memorandum is very complicated. So it is not an easy task to alter the contents of the memorandum. Whereas articles, the contents of articles of association can be altered easily at any number of times and at any times. Any number of articles can be added or deleted. So by passing a special resolution in the general meeting. So the contents of the articles can be altered easily. So these are some of the differences between memorandum and articles of association. So now comes to the multi-choice questions relating to the articles of association of this session of session 16. So there are 4 answers to be given for the question. So you have to opt any one question, one answer. So in that case, the correct answer. First question, that is the rules and regulations. So there are 4 answers. First one question is the rules and regulations for the internal management of a company are contained in its. So in which contains? First option is prospectus, annual report, memorandum of association. Last one is articles of association. Yes, the D point is the correct one. The rules and regulations for the internal management of the company are contained in its articles of association. Second question. The articles of association establish the relationship between. So there are 4 answers. First one is the company and its members, the company and its outsiders, the company and its members, and members inter. Fourth one, the company and other companies. Yes, C point is the correct one. The company and its members and members inter se. Coming to the third question. The articles of association can be altered by. Articles of association can be altered by first one, a resolution of the board of directors, an ordinary resolution in general meeting, a special resolution in general meeting, obtaining the permission from the company law board. As third answer is the correct answer. Coming to the fourth question. Articles of association are subordinate to. To whom it is subordinate? To which document is it subordinate? First one is prospectus, board of directors, memorandum and companies law. Fourth one, none of these. Yes. B point is the correct one. Articles of association is articles of association are subordinate to memorandum and companies act. Coming to the fifth question, the articles of association must be signed by. Who all have to sign the articles of association? All the directors, all the promoters, the auditors, all the subscribers of the memorandum. The fourth point is the correct one. All the subscribers of the memorandum have to sign the articles of association. Coming to the sixth question. An act is said to be ultra vires a company when it is beyond the powers. So there are 4 answers are there of the company, of the directors, but not the company, confirmed on the company by the articles. The fourth answer is the correct one. Coming to the seventh question. Which of the following companies need not have their own articles of association? There are 4 answers. Unlimited companies, companies limited by guarantee, private companies limited by shares. Last one, public companies limited by shares. So out of these, D point is the correct one. The public companies limited by shares. So they need not prepare their own articles. They can follow the table A as the model articles of their company. Coming to the 8th question. A copy of the resolution, a copy of the special resolution passed to alter the articles must be filed within the dash days with the registrar. First one, 15 days, 30 days, 45 days, none of these. Yes, first one is the correct answer. 15 days. Coming to the 9th question. Articles can modify the conditions contained in the memorandum. Yes. So which one? Articles. Can it be altered? The contents of the memorandum? No. B point is the correct one. The last question. A company can invest money in another company only if it is so authorized by its memorandum of association, articles of association, auditors, company secretary. Yes, B point is the correct one. So, articles of association contains the rules and regulations for the internal management of the company. See, whether it is related to financial matters or any other. The rules are the provisions specified in the articles. So, that is to be followed or that is to be authorized. So you can check out the key answers relating to the multi-choice questions. So the session outcomes. So the session outcomes are the students will be able to know the secondary document of the company, that is articles of association, its contents and differences between memorandum of association and articles of association. The learners can analyze and apply the provisions of company's law regarding articles of association and its contents. So you can refer the following books for company law and secretarial practice. Thanks for watching my video.